Hello. First of all, thank you, all of you, for being interested in our topic, which will be held within the business club REVERA Georgia. I would like to introduce the speakers today and the topic also. What about our webinar will be? As you are aware, now one of the hottest topic is how the foreigners and local employers should act in terms of new migration law changes which are imposed in Georgian legislation. And we, lawyers of REVERA, me, Melano Svanidze, Oksana Yasharian, and Nino Zautashvili, we will try to give you the information regarding this topic. Before starting our presentation, I will briefly mention information about our company. REVERA is an international law group which is offering to our clients legal and tax advising services within the Georgia and internationally as well. The company has more than 25 years experience, and we can provide to the clients very wide sphere of the services connected to the law. We have offices in Poland, Belarus, Georgia, of course, as well, Kazakhstan, Cyprus, and as well as we are offering to the clients legal panels in Armenia, Serbia, Belarus, Montenegro. So any trans-border legal requests which are connected to these countries, our company is ready to assist. So now let's briefly move to our agenda, what you should expect during our presentation. So to give you information regarding this sphere, our company already have one seminar and a webinar as well, because the amendments have been done step by step, and new cases and new topics we are arising. So today we will try not to cover not to talk in details regarding the articles. Of course, we will mention most important articles which is connected to the migration changes, but we will try to give you more practical view and advice which we already have within this period. Also, presentation will cover the changes which was done by the ordinance in 20 February of 2026, and as well as the latest amendment which was done on 15th April. Let's start and to understand why everyone is asking a lot of questions regarding these changes. Next slide, please. So this is the first time when in Georgia, foreigners for carrying out employment activities or entrepreneurial activities, they are required to have work permit. Of course, this is very new and fresh topic, and it's quite difficult to fully have all information and all procedures, how the things should be done, but we will try based on the legislation, practical cases, and our letters, which was addressed to the ministry, to somehow give you this information. So, of course, from the government now there are requirements for the work permit to have these activities in Georgia by foreigners. Connected to this, then there are imposed the fines and tight deadlines, which employees, employers, and entrepreneurs and self-employed, they are obliged to be in this term and in accordance with the requirements of the legislation. Next slide, please. So what is the work permit and what does the self-employed foreigner means? This is the terms which under the changes in labor migration law have been imposed. So let's at first just briefly discuss what means this term, self-employed foreigner, and then we will move to the work permit. So self-employed foreigner by the government, it is defined that way. A foreigner who does not have a permanent residence permit in Georgia and who carries out labor activities in Georgia, including being an independent contractor, engaged in trade, services, or other type of activities, or otherwise engaged in entrepreneurial or labor activities, and the purpose of these activities is to obtain financial benefit. So this is the scope and description who are considered and which activities are considered under self-employed foreigner. So self-employed foreigners needs to receive a work permit from the government to carry out the activities which was defined in this term. So an official body who is authorization to receive this work permit till today is defined State Employment Support Agency under the Ministry of Internally Displaced Persons, Labor, Health and Social Affairs of Georgia. It grants a foreigner national the legal right to carry out employment activities in Georgia, to be engaged in entrepreneurial or business activities independently, and work for a local Georgian employer in Georgia. So if you are these kind of persons, or you want to carry out these activities in Georgia, now you need to receive work permit. Of course, there are some conditions who does not need and under which grounds you don't need to receive work permit, and this will be discussed by me and by colleagues as well. Who must apply for the work permit? Any foreign national without permanent residence permit in Georgia must obtain authorization like work permit before being hired by a local employer in Georgia, performing paid work in Georgia, conducting commercial activity in Georgia. So performing paid work in Georgia, it means like being engaged based on contractual relationships, and providing services, trade, or working as an independent contractor. So here should be also noted that if person receives the work permit, this work permit is authorized for personal purposes on specific for specific activities. So, and of course, this permit cannot be granted to anyone. And if you received permit as a ground of being employee, and your conditions or position is changed, you need to receive new work permit. And if person received work permit as a self-employed foreigner, it is usually granted for specific professional, specific business activities. And if you are changing your activities or you have several activities, you need to receive another work permit. And I would like to also highlight the changes which was included in the labor migration law. Government imposed quotas for some activities. So it is like the minimum or maximum minutes of the work permits, which will be issued annually for specific spheres. So we can you can see now in the slides that this 1 year quotes which are now imposed for courier services, unfortunately it's 0. It means that person cannot be employed or cannot have business activities if he is foreigner in the sphere of courier services. The same is for the passenger transportation. So foreigners cannot receive work permits within the 1 year. Also, the same provision is for the guide services and for the mountain, alpine, and ski ski guide services for tourist purposes. Government imposed quote 200. What does it mean? Within the 1 year, only 200 work permits will be issued for these purposes. So it means that who will be first, and this 200 limit will be already filled, then applicants will receive no for receiving work permit on that spheres. Next slide, please. Yeah, and we are somehow happy that there are some grounds and cases in which foreigners, they does not need to receive work permit. So here on this slide it is demonstrated these cases in which occasion you don't need to receive work permit. I will not talk to all of them, but I will choose some which I think that it's more people have more questions regarding these activities, and I will talk about this. This is full remote work and senior management. So what does it mean? So if you are employed on Georgian employer and you are giving employment services, like your employment duties you are carrying out fully remotely from abroad, it means that in that regard, not employer, not employee are not obliged to receive work permit. Just ordinary labor relationships, like having the labor contract, defines the mandatory provisions which should be defined under the law to be employed in Georgian enterprise. Parties, they can have such kind of contract, and they don't need to receive work permit. And there is also new ground which appeared after the changes on 15 April. And I will try to first read how it is mentioned in the decree. So there is such provision. So if person carries out management or administrative activities provided for by the law of Georgia on entrepreneurs in an enterprise of the first, second, or third category, as defined by the law of Georgia on accounting, reporting, and audit, or carries out activities in the audit committee. So what does it mean? Let's step by step define this provision. Who can be considered under management or administrative activities? Usually, this company director and management and administrative activities are carried out by the directors. But what means this first, second, or third categories? So, in the law is defined from the purposes of financial and accounting aims, which enterprises are in which category. So, just to read only the third category enterprise description, this is written that way. An entity, so the third category entity is an entity that is not a fourth category enterprise and whose indicators at the end of the reporting period meet at least two of the following three criteria. First, the total value of assets does not exceed 10 million GEL. Income does not exceed 20 million GEL, and the average number of employees during the reporting period does not exceed 50. So we can say that if the enterprise falls under these conditions, and we can agree that a lot of companies, they will fall under this description, it means that the directors of such kind of enterprises, they don't need to receive work permit. And usually, to think logically, all enterprises, they can fall under this description. From this exception, we can say that directors, they are not obliged to receive and to address for work permit. Next slide, please. So now the more details connected to employee and employer regulations will be stated by my colleague, Nino. Nino, please.
Thank you, Melano. I will continue talking about a hiring process for foreign employees, and let's step by step look through these procedures. Firstly, we can discuss about two cases. First is when we don't have this employee previous time, and we are going to hire it. It means that we have not registered it on the labor migration portal till 1st March, and now we are hiring him in our company. So in this case, the legislation told us that we need to post vacancy about this vacant position, and it should be done on the portal WorkNet.org. This obligation means that when we have a vacancy, we should to post it on this portal and wait till 10 working days to get reply from the agency. So what reply can we get from this governmental body? The agency is looking through local specialists. Maybe someone who is Georgian citizenship can apply for this vacancy. And in this case, we should look through these candidates and reply to the agency if someone will be eligible for us. So for these procedures, we have a time frame. We should notify the agency in electronic way within 3 working days and explain why we reject this candidate, or maybe he is acceptable for us. If we reject it, the agency receive our response and our reasons, and after discussing and after 3 working days, the agency can apply and return the answer if we can hire our foreign employee in our company. If we have this accept, we can start other step-by-step procedures. But there are exceptions in the legislation regarding 10-day vacancy posting. And according to the terms, if we have international company or innovate startup company status, or maybe this position which should be posted is connected with individual necessary foreign specialists, or if cumulatively there are 2 options, high salary that is indicated as 15,000 GEL, and also high qualification positions, we are not obliged to post this vacancy, and we can start hiring foreign employees for the step of obtaining work and applying for the work permit. Next slide, please. Let's discuss about required documentation. So after we receive the accept from the agency, we can apply for our foreign employee on the portal. We should do it through the portal Labor Migration .org. And if we are talking about a firstly employed employer, we should fill the fields about company details, responsible person, foreign employee data, position and qualification. It is important because when we are applying for the foreign employee, we should indicate for what position he should be hired. Because as Milano mentioned about, if he is choosing another positions or his qualification is another, he should obtain another work permit. Second step is to pay fee, governmental fee for this application. The legislation oblige employer to do this, and not employee is obliged to pay this fees himself. So there are two ways. First is standard application fee. It is 200 GEL and means that we can receive answer from the agency within 30 calendar days. And the second way is more is faster and includes 10 working days for 400 GEL. Also, we can mention that there is renewal fee, as you can see on the slide. It costs 200 GEL, and a decision is issued within 30 calendar days. The method of payment is by card through the labor portal, and no paperwork is needed. Also, I would like to mention that if we want to skip this step-by-step plan and we are going to hire the foreign employee without work permit and without these applications, we would be fined, and the fines are as follows. Firstly, when we are hiring the foreign employee without a work permit, we as an employer would be fined for 2,000 GEL at first time, and also the employee would be fined from the government for 2,000 GEL. If we are repeating this breaching of the legislation, the fine will be doubled, and the later procedure is a triple fine if we are continuing to employ our to hire our employee without work permit. Next slide, please. So let's discuss about application submissions and specific of signing this application. As I mentioned above, we are doing this application and filling this information through the website, through the portal. So the method of signature and signing these documents is electronic signature or electronic stamp. It is by your choice, and you can choose yourself which one is more acceptable for you. Also, I would like to mention that that after submitting this application, agency is agency sends us approval of or refusal for obtaining the work permit. Refusal does not mean that it is the last decision, so we have right to appeal this decision. We can appeal it in within 1 month from official notification of the decision. But the important point is that appeal does not create a right to work. Appeal does not suspend obligation to leave Georgia, and if the deportation review of enforcement is in progress, it does not stop this process as well. Second, please. To continue our step-by-step plan, we should mention the connection between work status and immigration status. As we mentioned, the foreign employee should obtain the work permit, but it is not the last step that should be done in this process. So, additionally, he should apply for immigration status. Let's discuss about several cases. So what does it mean to apply for immigration status? If the foreign employee is going to continue his employment activities in Georgia and he is going to arrive in Georgia, he should do these steps. If he is outside Georgia, he must apply for the visa no later than 30 calendar days after receiving the authorization of work. It means obtaining work permit. And a work authorization alone does not automatically grant entry rights. So the second case is if the foreign employee is already in Georgia, he must apply within 10 calendar days for employment residence permit or IT sector residence permit. So if after obtaining this residence permit, he legally can stay in Georgia and continue his employment activities. And what about exceptions? Legislation assumes that no additional steps after receiving work permit is necessary if the foreign employee already has Georgian residence permit, and it could be any valid Georgian residence permit, not only employment or IT sector. But if he does not have it, the two ways to apply for this residence permit is only employment or IT basis. And the key principle is that work authorization, so obtaining work permit, and immigration status are linked process. And obtaining one does not mean that you are legally in Georgia and you can continue your employment, start or continue your employment activities in Georgia. So that was the process of hiring the employee by the national employer, and my colleague Oksana will continue about self-employed foreigners in Georgia.
Thank you, Nino. So let's move to the most overlooked topic in these new regulations, aka individual entrepreneurs. So, like crazy changes have been made in our new regulations since 1st March. Firstly, as you may know, the individual entrepreneur didn't have a chance to work from abroad remotely, and he needed to stay. He was obliged not to be abroad for more than 6 months consequently, meaning at one time. But now things have changed, and there are three categories, and let's look through to make clear which categories need work permit, residence permit, and neither of them. So first category is an individual entrepreneur who works in Georgia and who works for a Georgian client. So if you are considered an individual entrepreneur working from Georgia and you are giving services to a Georgian client, meaning Georgian residents, legal or physical persons, you need both residence permit and work permit. So the first step will be getting a work permit and the second getting a residence permit. And the obligation for you to not be outside of Georgia for 6 months consequently is still valid. The second individual entrepreneur case is when you are working for Georgian clients, but you are working remotely. So now you have that ability, you can do that. And the only thing you will need in that case is a work permit, just a work permit. And the third type of individual entrepreneurs are just the individual entrepreneurs who work exclusively for non-resident clients. So it doesn't matter if you are an individual entrepreneur working remotely or working from Georgia. If you are working for non-residents, you are giving services to non-residents. In that case, you don't need nor work permit, neither residence permit. For the ones who are obliged to have a work permit and residence permit, the procedure is quite the same as for the employees. In this case, just the procedure is done exclusively from the side of self-employed, meaning individual entrepreneur itself. It is worth to mention in this case that for the individual entrepreneurs who need work permit and residence permit, or just work permit, they have a deadline till 1st May of 2026. So if you should hurry to get a work permit and apply for residence permit, not to have issues and not to get fines afterwards. And regarding the requirements for the residence permit for individual entrepreneurs, which is turnover, an annual turnover of 50,000 GEL. Unfortunately, we do not have clarification yet from the ministry nor the agency, but the practical advice we can give to you is if it is possible, just to work remotely for some periods with a work permit, gain that annual turnover of 50,000 GEL, get visa D, come to Georgia and apply for residence permit. So for the step-by-step process, how to get that work permit as an individual entrepreneur, as mentioned before, the process is quite the same. There are a little changes, a little differences from the process of the employee. So the self-employed individual entrepreneur applies for work permit electronically via labor migration Mogoji. It uploads all the required documents and information about self-employed, which includes certificates of small business status or certificate from Registry of Economic Activities if you do not have a certificate of small business status, certificate of your turnover from the revenue service, and the information about your education and experience. After you apply and you pay the fee, which is the same as for the employees, meaning it is standard 30 calendar days, which is 200 GEL, and expedited 10 working days, which is 400 GEL. You pay that by your card, and then the agency reviews your application, and at any moment, it can ask you to correct something on your application, or just invite you to a mandatory interview. Please take note that the interview is mandatory and you cannot choose not to go and participate in that interview. So please be attentive because you get invitations to your interview via email. Check your spams, check everything on your email so to be sure you didn't miss it. And after that, after the interview, you get a decision of the agency on approval or refusal to your right to work permit. So let's one more time make clear when the work permit is required, is needed. So the work permit is not needed if you are an individual entrepreneur who works exclusively for the beneficiaries, for the clients who are non-Georgian residents. And if you are working for the clients who are Georgian residents and you are performing a long-term services, so work, and you are supporting a business in Georgia, then you will need a work permit. And if you are in place in Georgia, you will need also a residence permit. After you get that work permit, so it may be clear that it is not indefinite, and there are several grounds why it can be terminated at any moment. So first of the straightforward grounds is employment contract ends. So that means that when you are an employee for a Georgian employer and your contract ends and your employer doesn't prolong it, then automatically your work permit also terminates. As for the self-employed who are working from Georgia and in Georgia and working for Georgian beneficiaries, clients, and need to be in Georgia are obliged not to leave Georgia for 6 months consequently. If you leave for 6 months consequently, your work permit is also terminated. Also, D1 visa is very important, is also tightly connected to the residence permit and work permit in this case, regarding according to the new rules. So be attentive, because if you lose the time to apply for D1 visa, or if you get D1 visa and come to Georgia and do not apply in time to your residence permit, and D1 visa expires in that time, your work permit also expires. As well as when your residence permit expires and you do not prolong, and you lose the time to prolong it, your work permit will also terminate. So please be sure to apply in time and be attentive to the rules. Negative immigration decision and deportation and expulsion will also lead to the work permit termination. And there is a really important note for the employers. It's their obligation, if there is a negative decision, so if there is a termination of the work permit, the employer must terminate the employment contract with the employee within 5 days and submit the mandatory information to the agency. The agency passes that information to the State Services Development Agency, which is responsible for the residence permit. And that means that your work permit, residence permit are terminated. And finally, last but not least, IT residence permit in Georgia. This is also quite a new instrument in our labor migration, which is really quite attractive for our IT specialists. As you may already know, IT residence permit is for both employees in IT specialities. So all IT specialists who work in Georgia as IT in any company, and individual entrepreneurs who hold IT activities. IT residence permit is not an exception as well for a person to pass the work permit, and you are obliged to get a work permit before applying to IT residence permit as well. And there is a quite important note for IT residence permit that you may not, you may be in Georgia for 185 plus days in any consecutive 12-month period. So you should not miss that as well. Why is IT residence permit better than, for instance, just an ordinary employment residence permit? Because IT residence permit is given for a 3 years period, which is different from the ordinary, because the ordinary residence permit is given for 6 months or 1 year period at first time. And IT work permit for IT specialists is also given for firstly for a 3-year period, in difference with the ordinary work permit, which is given for 1 year period every first 5 years. So first 5 years, ordinary work permit is given for 1 year, for 1 year long. So that's it. And now I'll pass the floor to my colleague Melano, and we will also consider the most interesting, I guess, part of today, which is practical cases.
Thank you, Oksana. I would also remind to our listeners that please consider that after the presentation we will answer the questions which you had or you just now have during our presentation. So please feel free to write it to us so we'll be able to answer on them. So as promised, we will try to share with you some practical cases which we already had or we know that it have been in practice. What happens if an employer wants to continue labor relationship with the employee before the end of the year? So why we decided to say this case? Because under the law we know that employers who had employed foreigners before the 1st March and they had registered them in the portal, the government gave to them grace period till the end of the year to receive the work permit. And everyone thought that if I already have registered them, under any circumstances, I will not need to request from my employee work permit. But in practice, it seems differently. So, for instance, if you had your labor contract with your employee already registered on your portal, but the term of the contract is expiring till the end of the year. So it means that, of course, you should continue relationship with your employee and make the changes on the portal, but unfortunately portal is not giving to us the option just only continue relationship with them. So as long as we will upload and we want to upload prolongation of our labor contract, we are filling the application and the portal is giving to us the conditions which is necessary to obtain work permit. So it means that if before the end of the year, even after 1 month, term of your employee's contract expires, it means that you will need to apply for work permit as well. Also, this is the case because we already had in practice and it was needed. We continued the contractual relationship with the employee and in parallel we requested for work permit as well. Also, there is some practical advice for uploading the application because as you know, when the employer is applying instead of employee to receive work permit, when the application is finalized, it should be signed digitally by digital signature, which is not like other digital international programs. This in digital signature, it is meant the ID card option with Georgian, which is issued by Georgian government, and you should have the port where you are indicating your ID, residence permit or ID, and you are signing with by this mean electronically. But sometimes there is that company does not have any stamp, and even director doesn't have this digital electronic signature. So what we should do in that case, we had already practical experience there, and of course double checked in advance this information with the ministry that if you have employee with whom of course you have labor contract, it's receiving salary and you can prove that it's your employee, and that employee has this electronic signature, you can use their signature. Just it does not mean on which position this employee is appointed in your company. Just the attitude of the ministry is that if you are allowing this person to sign, this application, it means that they have access with the application based on your consent. So they accept such kind of signed applications and they review it. So in our case, there was a signature of lawyer and they accepted such kind of application. And we had also another practical case, which is also obliging employee to address for work permit earlier than end of the year, even though it was registered on the portal till 1st March. So if your employee has residence permit and the residence permit expires before the end of the year, and you need to address the sufficient bodies for prolongation of residence permit. Of course, there are requirements and deadlines that you should address at least 1 month before it expires. So you should consider that you already should have a work permit as well, that registry allowed you to continue your residence permit. So one more time to repeat. So you can't make prolongation of residence permit if you don't have work permit already. So in that case, it means that before the end of the year, even though the deadline which is provided from the government, you need to request the work permit before that term. That was usually the cases which already we had in practice. We all know that in practice these procedures it's not started for a long period. I think Oksana also mentioned the practical case regarding the interviews as well, to check the spams, and even the email can be reached 1 day before your application, so you should be very attentive to your email. And also there have been the case when the individual entrepreneurs, they had appointment, and on that date when the appointment was scheduled, the applicant entered the link, but from the representatives of the sufficiency body, no one appeared. Unfortunately, the applicant did not had a chance to have an interview, but it was smartly done by them that they immediately started calling to the agency. They sent emails as well that they had appointment and no one appeared. Unfortunately, the term was expiring next day, and this applicant received rejection for receiving the work permit. So, but as then the applicant arrived in the ministry and showed the proofs that he really entered the call, but no one appeared. There was some misunderstanding. They had already sent the email as well, and the ministry, they considered these proofs from their side, and now they are deciding to give them work permit or not. So they renewed the application process. Yeah, this is from the side of practical cases. Now I think we can move to Q&A questions session. We already received from our attendees some questions, so we will try to step by step answer them. I will read the questions, and me or my colleagues, they will answer on it. So we have one such kind of question. Does the termination of work permit causes termination of residence permit? Actually, Yeah, this is quite this is a question that it's not so easily to answer because we've been discussing this issue as well, but I will try to logically answer on this question. In the grounds of termination of work permit, there is not directly of residence permit, there is not directly written that termination or suspension of work permit causes termination of residence permit as well. But what we can read from the legislation is that as long as work permit is terminated within the 5 days, agency is sending this information to the sufficient governmental body who is issuing the residence permits. And also in the grounds of residence permits, there is written that residence permit is terminated if there is no more the ground or activity based on which the residence permit was issued. So now to think logically, so if work permit is terminated, the labor employer also has obligation to terminate labor contract as well with this employee. Of course, if the work permit will not be continued or if labor contract will not be continued. So if we already terminated the contract and we already don't have work permit, so this means that the grounds based on which the residence permit was issued by the sufficient body does not exist, and there is a logically the high chance, and it should be that way, that residence permit also can be terminated. Of course, this answer is based on summarizing 2 or 3 legislative law or decreases, and from our side and opinion, logically, termination of work permit will cause termination of residence permit, of course, residence permit as well. Also, we have such kind of question. If the clients are entirely based abroad, in the work permit requirements for an IT residence permit, if the clients are entirely based abroad, is the work permit requirement for an IT residence permit waived, and how can we prove this? I think this question can be answered by Oksana.
Thank you. Yes, I will answer this question. So, to make it clear, so you mean if you are an individual entrepreneur who works as an IT specialist, whose activity is in IT, and wants to get an IT residence permit. So yes, in that case, if your beneficiaries are from abroad, so non-residents of Georgia, the work permit is waived, yes. And how to prove it when you are applying for IT residence permit? You do not need to do extra job. So when you are applying for IT residence permit, one of the requirements, as you may know, is to show experience of 2 years. And show how do you show that experience is by giving contracts, showing the contracts with your counterparties, showing them, I don't know, some transactions, bank transactions. Of course, if there is mentioned who is giving you money, who is and what is the purpose of that money transaction. So anyways, it will be shown that your counterparties are from abroad. So it will explain to them why you do not have work permit and why it is not needed for you.
Thank you, Oksana. We have other questions as well. There is also such kind of question. D1 visa required even for citizens of visa-free countries. And then there is also additional question of issuing the conditions, terms, and deadlines. The discussion of the conditions and the grounds for the D1 visa, unfortunately, doesn't fall within our scope of the webinar. But as for the first part of the question, Oksana will answer to our to person who asks the question.
Okay, so as for the requirement of D1 visa, yes, we can tell that visa in this case, if you get a work permit and want to come to Georgia to continue your work from Georgia, D1 visa is needed for all residents, all people, even for the citizens of visa-free countries. So yes, it is required. It is like mandatory to get D1 visa.
Thank you, Oksana. We also have such a kind of question. If I am the owner of the company and hold the position of director, do I still need to obtain a work permit? I think I will answer this question since this topic was covered during my presentation as well. So if we will look to the grounds, which is written in the labor migration law, the grounds in which cases work permits are not necessary. After the changes of 15 April, there appeared such provision that the persons who are involved in management or administrative activities provided for by the law of Georgia on entrepreneurs in an enterprise of the first, second, or third category, as defined by the law of Georgia on accounting, reporting, and auditing, or carries out an activities in the audit committee. So, based on this provision, we can say that directors who are the owners as well of the company, and if your company falls under the third, second, or first criteria of defined article, directors, they don't need work permit. So usually we think that this will cover all kind of legal enterprises. We think yes, and I will also add, it is not written in the question, but maybe this person is interested that the director will not have obligation of address for work permit, but this person anyway can be indicated as a director and as a person who has contract within the company on the portal. Because as we know, towards the director is not signed the labor relationship contract, but anyway, this director can be registered on portal. Yes, and we also have additional question. Are you obliged to have specific amount of salary to obtain a residence permit? I think Oksana will answer this question.
Thank you, Melano. So yes, there is an obligation to have a specific amount of not salary, but actually it depends on the type of residence permit you need to get. So if it is an ordinary residence permit and if it is an employment residence permit, then yes, you as an employee should have a salary more than 1,105 lari. And if you are an individual entrepreneur, or you can have approximately 40,000 gel in your account and show it. And if you are an individual entrepreneur, you need to show a turnover of your individual entrepreneur, which should be not less than 50,000 yen annually. And you need to have approximately 40,000 yen in your account. And if we are talking about IT residence permit, then you need to show an annual income of 25,000 USD in jail. So you need to have at least 25,000 USD income annually. So yes, that's the requirements for the residency permit in regards of some money or salary or income.
Thank you, Oksana. And we still have left some questions. Is it possible to continue labor relationship with already registered employee on the portal? This question somehow I think I covered with my practical case, but one more time I will repeat and answer without problem. If we have registered our employee on the portal till the end or before the 1st March, we know that government gave us a grace period that we can request work permit for such kind of employee till the end of the year. But if we need to continue labor contract before the end of the year to that employee, it means that we are, of course, we are uploading the changes in the term of the contract, uploading and clicking to the bottom of renewal, continuation of the contractual relationships, but in parallel we are filling application for work permit. So without addressing to work permit, we cannot continue labor contract to our existing employees. And we have also left some questions. Does a self-employed individual who generates income only from foreign clients need to obtain a work permit in order to apply for a residence permit? I think regarding self-employed individual, Oksana will answer this question.
So as mentioned before, no, doesn't matter what is the activity of the self-employed. If you are generating income exclusively from the outside and your clients are and their activity, their business activity is coming from the outside, so you do not need work permit. Do not need work permit, and you may get a residence permit if you want to. Yes, that's it. And I guess we have one more question, which is about the asylum status. So is asylum status equivalent to residence of permit, or it is a strong basis to obtain a residence permit? So to answer that shortly, asylum status is not straightly equivalent to residence permit, but it is when you already get protection, an international protection from Georgia, so you get that that status, so the process is finalized, then that is the ground to get a temporary residence permit. But it is not the same as residence permit itself. And there is one more question. So after applying for a residence permit, while waiting decision, are there any restrictions on leaving the country and re-entering under the visa-free regime? So maybe my colleague Nino can answer to this question.
Of course, Oksana. So there are not any restrictions regarding entering or leaving the country. So, based on the visa-free regime, you can enter and leave the country as you wish before you receive the decision from the agency.
So
Yeah.
the questions are finalized. So this is all. No questions. So hope our session and our webinar was quite good for you and fruitful and informative. So thank you for joining us and being with us in this time. And we will be online in touch, and we will be giving all the news and updates as soon as we get them. So thank you for your attention, and thank you to my colleagues.
I would also say thank you for attending our webinar within our business club format. And thanks to the colleagues as well. On this slide, you can see the QR code where are our contact details indicated. So if you will have any additional question regarding this matter or any legal matter connected to Georgia, you can address, of course, us. And just keep an eye on our pages, because our webinars and the seminars within the business clubs are annually held, usually on hot topics, which is coming from our clients, or usually from the activities which are ongoing in the country. So good luck to everyone, and thank you one more time. Bye.